Hey, everybody. Welcome to First Thursday, the monthly podcast from Labor Relations Information System. My name is Rick Polson. I'll be your host. I'm the executive director of LRIS. And welcome to the pod, or welcome back to the pod if you're a repeat visitor. Nice to have you here. This is our August 2026 episode. I think as we record these early in the month, I always just freak out at how fast the year is going. I can't believe it's August already, but it makes me kind of sad. Um, but I guess that's it. I'm just gonna have to be sad. So what I'm not sad about, by the way, I've been talking about basketball on this podcast recently, and like it seems like the beginning of every month there's some kind of wild swing in the fortunes of the Philadelphia 76ers. And like I was here, I think the beginning of the May podcast, we just beaten the Celtics. I was all fired up, and then we got humiliated by the Knicks the next month. And then in July, I was like, there's no hope for the Sixers. And over the last 30 days, everything has changed. So Jaylen Brown, little guy named LeBron James. I don't know if you ever heard of him. I don't see how much gas he has left in the tank, but like all of a sudden the Sixers might be a powerhouse. So if you know anything about the Philadelphia 76ers and the process and the history of all that, you know that it's going to get screwed up somehow. And there will be about 5 different really weird things that happen that are inexplicable, that can only happen to the Philadelphia 76ers. And the season will be an unmitigated disaster. Just my prediction. Okay, let's talk about labor relations information system stuff. We have a pretty interesting, I think, an interesting pod this month. We're going to talk about Brady and Giglio issues. We have one of the cases we're going to talk about is in our most recent version of the Public Safety Labor News newsletter. Another case is actually going to be in next month's, and then another case. I think we wrote about it like 2 months ago or a month ago. If we haven't, you're going to hear about it today. But we have 3 cases that cover, I think, 3 different aspects of the Brady and Giglio rule. If you're not a law enforcement officer, or you don't deal, if you're in fire service, fire and emergency service, and deal with those things, I still think it's worth a listen because we talk about, constitutional privacy issues. And, look, that stuff is getting more and more important as we give away more and more of our privacy in this world. And that stuff certainly expands into the workplace. So that's what we're going to talk about. And let me just give you a little bit of background, I guess. Brady and Giglio, or Giglio if you're Italian, are case names. The lawyers that listen to this thing, and then there's non-lawyers. Lawyers, we're such assholes that we call people who aren't lawyers non-lawyers, right? That's like we are the center of the universe. But so lawyers and non-lawyers listen to this thing, and we toss around case names. That's what we do in the law, right? Now that's Smith, that's Jones, because we cite cases that, and generally they're going to be Supreme Court cases or state Supreme Court cases, or cases that stand for propositions or rules, or cases that set tests that we're supposed to utilize, because we're not going to predict, hey, what's the outcome going to be in this particular dispute? And 5 years from now, ChatGPT will do all that for us, right? Or Claude, or some version of that. And there'll be 5 lawyers that work in this country. That's why I'm going to become a plumber. But, for now, we read the cases and we try to apply the rules that the judges set for us in the cases, and help our clients, navigate their way through a problem, or maybe even avoid problems. And so Brady and Giglio are the names of 2 different Supreme Court cases. And really, Brady is the main court case. And it generally stands for the proposition that the government has an obligation consistent with its obligation to provide defendants with a fair trial, that the government has an obligation to turn over information that would be helpful to a criminal defendant in a case. And, it's not just helpful, it's a little more serious than that. But that comes out of the Brady decision from the 1960s. And like every 10 years or so, the Supreme Court gives us a decision that fleshes that out. And that's what the court does. These days, the court seems to like just change their mind a lot and change the rules. But Brady Giglio jurisprudence has been pretty consistent over the decades, where about every decade, the court will help kind of focus the rule a little bit. And so we're talking about criminal law cases. And so why are we even talking about that? I'm not a criminal lawyer. I'm not a criminal either. I just throw that in there. I'm a labor lawyer and, work with public safety folks. And when you work with law enforcement officers and police unions in particular, you represent police departments, you're going to have to deal with Brady Giglio to a certain extent. And usually that's going to be in the discipline context. And sometimes it can be in the deployment context. And sometimes if we're bargaining rules around how to deal with these things, which I think we're going to talk about today. So there are implications outside of the criminal courtroom, which is why we're talking about this stuff on this podcast. And we talk about this at our seminars, our rights of police seminar and our discipline seminars. We usually spend an hour or two talking about what's new in Brady and Giglio. But this is a criminal law doctrine. And, for many years, they really were the concern of prosecutors and criminal defense attorneys, and judges, right? And so officers are going to hear about or would hear about Brady, issues if they're called as a witness in a criminal case. But labor lawyers didn't spend a lot of time thinking about it. That has changed dramatically. And, for a lot of reasons, I would say that probably the biggest reason is the rise of and subsequent fall of progressive prosecutors, what we call progressive prosecutors, in mostly in larger cities across the country. And this is the, whether it's Soros funded or who the hell knows, right? But you've got, what I think happened is, um, we saw about 20 years ago, state attorney generals, which historically had been viewed as really, that's your top prosecutor in state, your AG. State attorney general or state attorneys general became more active in areas outside of criminal law. And so being active in civil matters and taking a role on issues that may have more day-to-day importance to people. Most of us aren't criminals and most of us aren't law enforcement officers. And so I don't really care too much about what my state attorney general does, unless, wait a minute, he or she is talking about consumer rights that I might have or other things that might affect my day to day. And usually those are statewide elective offices that people will use to springboard to governor or president or whatever it is that they might have in mind. And so we saw state attorneys general become more active politically in areas outside of traditional criminal justice matters. And I think that became contagious and spread to local elected officials. Same thing. You want to be mayor, run for DA, right? You want to be governor, run for DA. You're going to be tough on crime, or you're not going to be tough on crime, which can be an attractive thing in one of the two major parties, depending on where you are in the country. And so we had progressive prosecutors, which could, that term even, that could just mean somebody is like, hey, we're going to follow the rules. We want to try to think, be a little more creative in terms of larger criminal justice matters. And, can we allocate resources in prevention? And, what is really to be gained by throwing somebody in a cell for 30 years? And are there other things maybe we can do? That kind of discussion, and usually those discussions you have by people who haven't been the victims of crime, but, there are some aspects of progressive DAs that I would say are maybe a little more mainstream. The bad stuff, and the abuses that you can see and that we have seen in San Francisco and Philadelphia and St. Louis and lots of places across the country are where you have defense attorneys that run for DA. In a democracy, man, anybody can run for anything for the most part. And if I'm a defense attorney and I want to run on the platform of nobody's ever going to go to jail in this city and people elect me, well, now guess what? I'm the new prosecutor. And if I run on a platform of FBFOP, which the district attorney of the city of Philadelphia, that's what they were chanting at his victory party in 2017, FBFOP, and they didn't say F. That's democracy can sometimes be an interesting thing. And that's what you wind up with situations where, and we have wound up in situations where prosecutors have been more aggressive. And that's when the Brady and Giglio stuff started to come to the forefront, I think, because now you had this tool that prosecutors or reformers could use to say, well, What we're going to do is we're going to go out, we're going to identify bad cops or dirty cops or Brady cops. And I'll talk about why, what the relationship is between Brady and those types of designations. But we're going to try to identify these folks and maybe force police departments to fire them, or we're just going to shame them out of the industry, right? And so, we had a lot of prosecutors that looked at the world that way, which kind of sucks because you're on the same team. If you're a police officer, that's the prosecutor, that you're basically working under to a certain extent in your county. But we have parts of the country where we have these really adversarial relationships within the quote unquote prosecution team. And so, we have DAs that are much more active, and even in places where you don't have progressive DAs, we've just seen Brady things be, more at the forefront. And so, Brady determinations and Brady issues affect hiring, they affect promotion, they affect certainly um, deployment of officers, they affect internal investigations, right? Discipline proceedings. They come up in bargaining because, in a lot of places we deal with Brady issues in bargaining, or I certainly do. And so, a prosecutor's decision to label an officer as having potential impeachment material, um, is a pretty serious thing, and that's where the cases come in. And so, under Brady, we have an obligation to disclose to the defense information material to the outcome uh, of their trial, right? Information that, had they known about it, that's in the government's possession, might have made a difference in the outcome of a trial. The government has an obligation to turn that over to a criminal defendant. And in a case called Giglio, it's about 50 years old. The Supreme Court, told us that obligation to disclose information helpful to a defendant includes information that could be used to impeach witnesses. And so, who are people who testify in criminal trials? Police officers. They do that a lot. Um, and, so if I've got information about a police officer who was just issued a 20-day suspension last year for lying 9 times, and now we've got a criminal prosecution that's resting primarily on that officer's testimony. If you were the defendant in that trial, wouldn't you want to know that about the police officer so that maybe your lawyer could cross-examine that police officer about the fact that he or she lied, last year and was suspended, et cetera. Like, so that's where uh, the the obligation to disclose information makes its way into a police department and affects police officers. It can affect their employment. Some lawyers, I mean, I don't look at the world this way, but some lawyers are like, oh, that's it. You put somebody in a Brady list, you end their career. They can never be a police officer again. That's not true. That's not accurate. Certainly not the state of the law in Pennsylvania where I practice, and it's not the state of the law anywhere, quite frankly. Some people treat it that way, and there certainly can be a negative impact on people's careers. But don't drink the Kool-Aid when someone says, "Oh, you can end an officer's career by putting them on a Brady list." I don't think it's that straightforward. Um, but it can affect um, your job security if you're a police officer. And so, we've got this era where there's more attention to Brady and Giglio issues, and we're also in an area where there's been renewed interest on transparency in government. And so we have courts, requiring departments to, to preserve information that might otherwise be private. We've got more, ways that we can store information, whether it's in our personal cell phones, and I have a case about that, or whether or not we're using AI, and there's an AI database of officer conduct and like who has access to that information. This is where all the Brady stuff kind of makes its way into the workplace. And so, far from being a prisoner of a criminal courtroom, Brady really is now a labor relations issue in a lot of ways, and certainly in law enforcement agencies. And so we're going to look at 3 recent decisions this month that illustrate, I think, where this area of the law is headed. And the first case comes out of Virginia, and it's interesting because it involves prosecutors seeking access to police officers' personal cell phones in relation to a discovery request in a federal criminal case. Um, Very interesting stuff there, and a little scary. The second case comes out of New Jersey, and it discusses and in that case, whether the public defender in New Jersey, the statewide public defender's office, has a right to obtain otherwise confidential internal affairs reports, and whether that exists under their state open records law, or even their common law, this deeper kind of common law right of access in New Jersey. And that's the kind of information, right? At least the defender in that case said it's information that we need in order to kind of make credibility determinations. This is information that should be disclosed to us under Brady. Maybe it is, maybe it isn't. And so that's why we're entitled to it. And the third case comes out of Iowa. It's a Supreme Court decision out of Iowa that really interesting in defining really the constitutional limits of placing officers on Brady lists, and just as importantly, the procedural statutory protections that officers are entitled to before and after that occurs. And a pretty interesting constitutional question to, answered by the Iowa Supreme Court. There, Iowa. Wow, Iowa's really interesting. The law in Iowa on Brady Giglio is in front of most other states. I just never know, right? Where these things are going to come from. And so we got three cases out of three different jurisdictions, in federal court and state court as well, and they share really a common theme. And it's who gets to decide, when an officer's credibility has become a Brady issue, and what protections exist, before and after that decision can be made. The answer to that question has pretty significant consequences. The determinations themselves are made outside of the collective bargaining process, and they're made, by a prosecutor. They're made outside of 99% of the time the agency that a law enforcement officer is going to work. But even though that decision is made outside of your agency, they're going to have pretty far-reaching implications potentially. All right, and so let's talk a little bit about Brady lists, or Giglio lists, before I jump into the first case, because I'm going to throw this term around, and the names vary by jurisdiction, but the concept is pretty similar. Prosecutors generally keep track of officers whose credibility may have to be disclosed in a criminal case under Brady. Brady v. Maryland is the full name of the case, or under Giglio versus the United States. Are prosecutors required to have a Brady list? No, they're not. Some states actually mandate a list. Others say you don't have to have one. Others prohibit a list. But it's basically a way that a prosecutor can keep track of who are the officers that have information that I need to disclose. And so if I'm in a county where there are 5,000 law enforcement officers, and I know that there's 20 that if they're a witness in a case, there's like stuff I have to disclose to criminal defense attorneys based on what's in their record. Anecdotally, we all kind of know who's the good witness, who's the bad witness, but we have to keep track of it somehow. So we write it down, we put it in a list, and whether that's kept in the bottom drawer of the DA's desk or whether that's on a computer in a database. The one terrible DA kept a police misconduct database, and he said, "There's nothing negative about being in a police misconduct database. What reputation problems could that pose for an officer?" But so there's just ways that you keep track of this stuff. Sometimes those lists are confidential. In some jurisdictions, there are disclosure systems that make portions of the information available, maybe only to criminal defense attorneys, or sometimes to the general public. And being placed on a Brady list, or being stuck on a Brady list, doesn't necessarily mean that an officer has lied. By the way, that's the main thing. It doesn't necessarily mean the officers committed any type of misconduct. In some jurisdictions and in some courtrooms, relatively minor policy violations might trigger disclosure. In other areas, prosecutors are going to exercise very broad discretion to decide what's potential impeachment evidence, and this can cut both ways. You've got some prosecutors that are going to not disclose. They're going to really, really go out of the way to not disclose things and kind of look at it in this is an adversarial proceeding. I'm not going to give the defense anything that could possibly stand in the way of me getting a conviction and putting this bad guy behind bars. That's all well and good until the defense finds out that there was exculpatory information that was not disclosed in a case, and now we've got a conviction, a murder conviction that gets tossed. Right now, that bad guy's back on the streets, and so we want convictions that are going to stick. I think, right? And we want to make sure that criminal defendants have fair trials, right? We want to take away every possible excuse, every possible avenue of appeal they might have, right? Let's get a good conviction, and let's make it stick. And so we have Brady violations that are, let's say, pro prosecutor, and then we have Brady violations that are pro defense, where the DA just discloses everything, right? Wants to give everything away, right? It used to be that with respect to disclosure, that I would always say that when cars used to have gas pedals and brake pedals, that the defense was the gas and the prosecution was the brake. Right? When you have progressive prosecutors, what happens when there's just two gas pedals? And that can be a real problem, right? And so, what we have is yeah, different systems in different places based on different elected officials, right? There's a lot of uncertainty. There's a lack of uniformity. Welcome to these here United States of America. That's how we do it. And so, if we have a finding of untruthfulness, that's always going to raise a Brady concern. But sometimes excessive force will raise it. Poor report writing. I don't know. Failure to activate a body camera, is that something that needs to be disclosed? How about insubordination? Just general insubordination. Bias, evidence of bias. Yeah, that probably should be disclosed. What about just being bad at your job, like a negligent investigation? I don't know. What you say on social media, does that have to be disclosed? All of these things, right? They're all going to vary one prosecutor to another, one state to another, one elected DA to the next, even in the same jurisdiction, right? You can have a really conservative person be followed by a really liberal person, same county, different Brady rules. And so, these changes present really significant challenges for unions, I think, for employers in the realm of collective bargaining, because, lots of CBAs are going to cover discipline, right? We may have pretty detailed procedures in that governing investigations, governing discipline, codifying Weingarten rights or codifying Garrity protections. We have just cause protections. We have arbitration. Most contracts don't have similar frameworks in place regarding Brady determinations, but we're starting to see that come up more and more. And so, why do we see that? Because we have lots of questions. Can an officer challenge a Brady determination? There's a question. Can we challenge that under the contract? What type of due process requirements are in place in relation to an officer's placement on or removal from a Brady list? And where do we go with those concerns? Or do we go to the DA? Do we go to court? Are they things that maybe we can address at our local agency before information leaves the police department and goes over to the prosecutor's office? All of those things, how much notice should we have? Maybe if the police department's going to send information over to regarding an officer to a district attorney's office, like, should they notify the officer? Are they required to do that? Should they let the officer know, hey, we don't know if this is Brady material or not. It's in a gray area. We're going to send it to the DA, let them figure it out, and let the officer, maybe raise an individual challenge. Those are the kind of things that we're starting to deal with in contracts in lots of different ways. And so the three cases that we're dealing with today kind of reflect maybe three different ways of looking at that. The first case comes out of Virginia. This is a federal court decision in Virginia. It's called United States v. David. This case was decided in April, late April this year, maybe early May of this year. You'll see it in the show notes. It seems to be just kind of a run-of-the-mill discovery dispute, but when you go through it, it's really anything but. It's a pretty scary case, I think, about personal cell phone uses. And so let's talk a little bit about the case. So this case really stems from a traffic stop in Roanoke, Virginia. Part of a larger investigation. Basically, it's a drug dealer investigation. So this is allegedly violent criminal enterprise in the Roanoke area. There's an investigation. Investigation results in a traffic stop. They get the canine involved, and we find guns and drugs. Woohoo! Right? That's what we like to talk about on this podcast. Don't worry, I'm not going to talk about marijuana or money or any of that other stuff, because in this particular instance, the defendant, Mr. David, not Larry David, by the way, it's Michael Antonio David, is the criminal defendant in Roanoke, was a convicted felon. And so, those two guns that he had in a hidden compartment in his car. Yeah, he wasn't supposed to have those. And so, we're moving forward with the prosecution, and there's a pretty run of the mill discovery request, submitted. In the workup to trial, the government produces, thousands of pages of discovery. They provide, in response to a request from the defense, communications among and between police officers on scene. Uh, Interesting request. And so in David's discovery request, he asked for all communication among officers involved in the surveillance, stop, and search that resulted in the arrest. Um, the government said, well, we're going to give you what we have. We don't have, anything documenting communications, between or among the officers, but we're going to give you, the normal stuff: written reports, body worn camera footage, dash cam recordings, etc. So what happens, right? So defense counsel gets the information, right? They're going through everything, and they see body camera footage. What do you see on the body camera? The body camera, it faces forward, right? And so an officer looks down, his body camera goes down and shows him texting another officer. Right? They're communicating via text in a way that's like, oh yeah, let me hold my phone off to the side. We can communicate. It's not going to be picked up on the body cam. Haha. Not smart in the system. I mean, this stuff's always going to happen. The more tech, the more things we introduce on scene, there's always going to be workarounds, because that's what people do. They come up with workarounds. And we have guys that are communicating, using their cell phones, thinking it's out of the camera range. It's not. And so defense counsel sees this and says, wait a minute, you told me that you produced all the information that we had in this case. And I just found a bunch of text communication between and among officers. And so they followed up and said, look, we want all of the texting on people's personal and their work phones in connection with this case. Wait a minute, personal and work. So personal phones. This is an agency that did not issue work cell phones to every officer, which, by the way, on the East Coast, that is very, very common. People on the West Coast are going to say, what are you talking about? But on the East Coast, a lot of departments don't issue cell phones, and people were going to use their personal cell phones for work. And that creates a whole host of problems. We talk about that stuff at our seminars a lot. Come to the Rights of Police seminar in 2027. We're going to be in Nashville. We'll probably spend a half day talking about, those kind of privacy concerns. And so here, though, this is what's happening. We have a department, people are using their personal cell phones. Somebody sees, a defense counsel sees people texting each other about the case on the cell phone. They say, all right, I want to get into everybody's personal cell phone. Great, right? We don't get into some of the deeper privacy protections and Fourth Amendment protections maybe that police officers might have in this case, although we do get into those sometimes in different cases. This case, the court really, the fight was over discovery. And so what happened was the police department went back and they performed really like an ad hoc review. And it was, I don't remember, it was the sergeant was on duty. He was like, hey, guys, anyone text each other that day about case, and some people responded, some people didn't. Some people had automatic deletion of their texts set up on their personal phones. And so some people responded, some people didn't. The government responded and said, here's what we have. Defense counsel reviewed it and said, and they found more communication that, Officer A, I have a picture of Officer A's cell phone communicating with Officer B, but you haven't given me anything from Officer B. So I know that there's responsive communication made by Officer B and you didn't produce it, right? So there's all these types of problems with respect to the government's response to this discovery request. And so what the defense counsel says is, or argues for, is they ask for a forensic examination of all the devices. And so they filed a motion to compel forensic review of every officer on scene, their personal cell phones and their work cell phones for any communication related to the investigation, the arrest, including, right, any of the, you guys know how detailed a forensic exam of somebody's phone can be, right? And if you need a warrant, generally getting somebody's cell phone for a good reason. because everything is on there and it's pretty much always on there. And so um, this discovery stuff was litigated for like a year, right? And throughout this battle, more and more undisclosed communications surfaced. And, it's because like some officers said they only searched part of their phones. Others didn't really know what the prosecutor was asking for. Some, didn't search their deleted message folders. Some didn't know they had deleted message folders. It was that kind of patchwork discovery response that even the court noticed is like, hey, man, if there was a grand jury subpoena asking for this stuff, and this was the response that the subjects of the investigation came up with, the government would be pissed. And here the government is basically defending that type of response as appropriate. Um, all this made its way before the court. And not surprisingly, the judge determined that the government's discovery response was fundamentally inadequate. And the judge made clear in the decision to note that nobody was acting in bad faith. It just was that there was a systemic failure on the police department's end and within the prosecutor's office. More importantly, because ultimately the obligation runs to the prosecutor, not the police department. Right? I think that was Kyles B. Whitley decided in the 80s, a Brady decision that basically says that this obligation, to disclose Brady information, it extends to the entire prosecution team. And it's not sufficient for a DA to say, well, I asked the police department and they didn't give me anything. No. That's the prosecutor's mistake right there. Right? The prosecutor is going to be responsible for the police department. And that's why you have prosecutors that assert themselves and try to be really clear about, here's what I need to know about. Whether you want to give it to me or not, you have to give it to me because I'm responsible for it. And in this particular case, the court determined that these discovery failures resulted from a system that was just completely incapable of reliably locating responsive evidence. And it wasn't necessarily, or wasn't not necessarily, it wasn't intentional misconduct. It was a structural problem. There were no preservation procedures related to officers' work cell phones or officers' personal cell phones. There was no type of forensic collection performed as a matter of course. There was no centralized repository for any of this data. Think about your body cams. You plug them in at the end of the shift. Everything is uploaded. Everything is centralized. This is the equivalent of like just not doing that and people having body cams at work. And, hey, Joey, can you upload that information related to that particular arrest? Oh, yeah, let me see if I can find it. Like, that's just not going to work, right? We have centralized systems in place so that we don't screw up. None of that was in effect here, with respect to possible cell phone communication between and among officers on scene. And because there was nothing in place, of course, the process failed, and it failed repeatedly, over the course of really a year of discovery disputes. And so the court reiterated that point, made clear that the constitutional obligation belongs to the prosecution team as a whole, and that includes every single law enforcement officer participating in the investigation. And if those officers possess responsive evidence, even if it's on their personal phones, that evidence, according to this court in this case, is effectively within the government's possession. And so, real, problem there. Right? What did the court wind up doing with the case? The court did what you thought, right? It required a forensic examination of the officer's cell phones. Now, it was a focus. The court ordered a very focused review, and I think did so in a pretty responsible way, right? We didn't just say, okay, turn over your phones, we're going to review your whole phones, because we know that the modern smartphone, contains a ton of personal information, medical, family, financial, you name it, right? It's all on your phone. And so ordering the wholesale disclosure of an officer's phone would then implicate pretty serious Fourth Amendment and privacy concerns on the officer's end. And so what the court wound up doing was ordering a focused forensic review, where we would identify an independent forensic examiner, not defense counsel, to conduct an extraction. The court in the decision, put pretty clear fences around the examiner's review and really limited the areas of the phone that could be reviewed. So the examiner would only search for specified categories of information. The searches were limited to definite time periods. The results of the forensics exam are then provided to the government first so that the government could then review for privilege and relevance and responsiveness. Then, still, defense counsel doesn't get it. It goes to the court for in-camera review. And then the parties could argue after that, regarding what needs to be turned over or not. And so a pretty interesting case where we have a Brady dispute, right? This is a kind of, there was some federal rule discovery, but also Brady obligations, involved in that, got to, all right, I want to know what's on the officer's phone. Let me get into that officer's phone. And we had a court kind of try to identify a middle ground here in ordering the disclosure. But the bad news is, if I'm a Roanoke police officer, the government got into my personal cell phone, and by the way, the government got into my cell phone. Some of my information got turned over to defense counsel of, some drug dealer in Roanoke, which is not really what what you want to, deal with. And so I think we need to be really careful about using personal devices, at work. The practice has become increasingly common. I don't know why. You would think that because officers are using their phones more and more, that agencies would more and more agencies would be just issuing cell phones to officers, but they're not. Some people get it, or detectives get it, or we have a shift phone or something like that. But they're not just issuing phones to officers. And, that's a real problem because people are texting constantly. I get tons of cases. There's tons of things that come our way at LRS related to the shift text chain and things that happen or are said, or photos that are attached to that shift text chain. Yeah, man, you can get some pretty good cases that way. And so, and I understand why people do it, right? Texting is fast. Photos are easy to transmit. We're just used to communicating that way, but we have to be really clear about how we're going to use them. Personal cell phones, were not designed to function as evidence management systems, right? Messages disappear, or you could have a texting app where they're designed to disappear, right? Phones get upgraded, backed up, things are lost. Things are sent to the cloud. I think agencies really need to think about whether or not it's appropriate in 2026 to have people using personal cell phones. What if I'm in an agency, or you're working in an agency that does use personal cell phones? And I've seen this come up in bargaining where I'll work with an agency where they use their personal cell phones, and I provide my perspective and say, guys, there's a lot of risk here. This is, are you sure you want to do that? And it can be a controversial issue because some people are saying, absolutely, I want a work cell phone. I don't want to have my cell phone with me. They don't want to have two cell phones. They don't want to deal with all the BS. And it's just a matter of convenience for them. I'd rather have it all on my cell phone. I'd rather have the Planet scheduling app and my email and all that stuff on my personal phone, and I'll take the risks. Lots of agencies and lots of unions prefer it that way. If you're in an agency that does that, I would recommend, and we've done this with a lot of contracts, bargain language into the contract addressing, not what happens. This is a criminal case, and we got a judge involved, and we got in-camera review, and we have all those protections in effect. What if it's just a discipline investigation in the agency? I use my personal cell phone for work, and there's some allegation, and Internal Affairs is conducting an exam. As part of the exam, they're like, "Hey, Rick, give me your cell phone. I want to look at it." What do you do then? I hope your first reaction is to say, no, you're the government. I'm not going to give you my cell phone, government employer. The question is going to be whether I have a reasonable expectation of privacy. Now, if the government asks me, Rick Polson, for my cell phone, I can say, get a warrant. I have an expectation of privacy in my phone. I'm not going to just give it to you. If you're a police officer and you use your cell phone for work, and you have a scheduling app on your phone, and you have email on your phone, and maybe you even get a stipend because you use it that much, you've negotiated a stipend for your phone. Well, I don't know. Have you given that privacy away? Do you still have a reasonable expectation of privacy because you use this thing so much for work? And the answer to that question is going to vary case by case, place by place, based on the facts involved. And those are the kind of things we talk about at seminars. But it's certainly, something that maybe you don't have an expectation of privacy. So what I would recommend is that you just get in the contract language saying, hey, yeah, okay, we're going to use our personal cell phones for work, but the department cannot compel an officer to give them their personal cell phone as part of an investigation, absent, of course, like a court order or something like that. You can at least address the administrative impact of it. One of the fallout, potentially of this case is if you really think it through and you're in a department that where people use their personal cell phones and you're a chief of that department or you're a prosecutor in a county, you have to put some type of system in place. So what does that mean? The people have to, you know, upload information from their cell phone at the end of every shift to the extent they've used it. Do they have to disclose shift by shift? Did I use my personal cell phone for work? If so, when? How's that information stored? I mean, nobody is doing this. Nobody is doing this. And for good reason. And I think the question that comes out of this David case that I don't have an answer to, I'm just raising as a question, is should we do that? And, is that going to be such a pain in the neck that maybe the best situation here is to be really clear at the agency level, say officers cannot use their personal cell phones under any circumstances for work, period, end of story. And here's a work cell phone. And yeah, it's going to cost us money to buy the hardware. And yeah, it's going to cost us money to provide service. But, we pay for your uniforms and your weapons too. This is just part of the job. I think that that's where it's going. And if you're not there, it's something that I would recommend you explore at the agency level. If you have questions about any of that stuff, take a look at that U.S. v. David case. It'll be in the show notes. Okay, our next case is a state court case out of New Jersey, and it is New Jersey Office of the Public Defender versus New Jersey Department of Law and Public Safety. Actually, this is the case that was decided in late April 2016. The David case that we just discussed, that was decided June 30th, so that case is pretty new. Sorry, I got the date wrong on that. So this is the oldest of the three cases we're going to talk about today. And, how does this one relate to Jersey or relate to Jersey? It relates to Jersey because it's out of New Jersey. It relates to Brady because it involves a request by defense counsel, in this instance, the statewide public defender service in New Jersey's court system for internal affairs reports in Essex County, New Jersey. Originally, the request was for basically 10 years of internal affairs reports with, not redacted, with all the names, all the information. And it's relevant to the Brady thing because it really it addresses concerns about access of information when the government is asking, when you have the government attempting to discharge its Brady obligations, and whether this is good prosecutor, bad, it doesn't really matter. When the government is attempting to meet its Brady obligations, and we have a prosecutor's office or the state attorney general sending dictates to local police agencies, informing them of information that must be turned over to their prosecutor so that, one of the reasons anyway, so that a prosecutor can discharge their Brady obligations. Well, how much of that information now is a public record that has to be disclosed, right, to anybody? Right, under a public records law or to defense counsel or to an organization of defense lawyers, under the state open records law, or in this particular case, under common law. And so, we can have lists. One of the reasons why, hey, we have Brady lists because they're easier. It's easy to have a list, right? I can keep track of things that way. But, there's long distrust in this history of lists, right? I don't want my name to be on any list. My name's on a list, especially a government list. And so if the government has a list and my name's on it, well, I'm concerned about that. And if the government has a list with other people's names on it, well, shouldn't I as a citizen get to know like who's on what list and for what? So this is where it becomes, an issue. And so if we're going to maintain these Brady lists, we have to think about public access and what are the public access implications of these processes. In Jersey, it's pretty interesting because, New Jersey had systems in place, for a lot of years. Jersey has a very strong and active attorney general system. Attorneys general in New Jersey can basically issue rules that are mandatory on all law enforcement agencies in the state. And so, if the attorney general, issues a memo, um, that's going to be, or they make changes to their policies and procedures manual, you might say, okay, well, that's like a best practice or something. We'll take that in mind. No, in Jersey, this stuff is mandatory. And we see a lot of litigation, sometimes between the attorneys general and either police unions or agencies over dictates that come from the state. And a lot of times we'll report, on those cases at LRIS in the public safety labor news. This is, really kind of one of those things. And so there are a couple of requirements. There are lots of requirements, regarding disclosure that come from New Jersey's attorney general. And um, those requirements became much more strict before George Floyd, probably around 2019. And there's politics involved there. There's particular attorneys general that are going to be more aggressive than others. I talked about progressive DAs earlier, and some of that was happening in New Jersey. And then George Floyd happened, and we saw all kinds of changes with respect to law enforcement agencies and disclosure and discipline all across the country. And New Jersey certainly was not immune to that. And this case in New Jersey involves actually a number of different changes, mandatory changes that came from the AG's office to prosecutors' offices and law enforcement agencies that some of these were just knee-jerk reactions to Floyd. Two of the orders were issued. They were dated June 15th of 2020. And so, listen, nobody was thinking with their right mind then. And so a lot of stuff that happened in June of 2020 has since been reversed or limited in a lot of ways, including in New Jersey. But one of the things that was done by the AG in 2020 and then refined in the years following was a mandate to standardize disclosure of police discipline related issues to prosecutors and to the public. And that's what this case, really concerns. And the specific request here was made by the public defender's office, for things they call an Appendix K report, right? And it's a particular report that contains information related to internal affairs reports at agencies. And so, leading up to these changes, that were imposed over the last few years, Jersey, followed a pretty typical approach that was followed in many states. You'd have internal affairs investigations, and they were generally considered confidential. And so, prosecutors certainly would review sustained internal affairs findings involving dishonesty or misconduct as part of their general Brady obligations. Those files themselves, they remained within the law enforcement team, right? And so defense attorneys would rarely have direct access to the underlying investigative materials if the underlying materials didn't rise to the level of a Brady disclosure. And we'd have an important kind of middle operator there is the court, right? Disputes over access to things are going to be resolved by the court in an in-camera review, generally. So defense counsel would have some access, controlled access, and the public had even less, which makes sense. These are private, investigations that, do you want every investigation into you just being kind of out on the street? Right? You may not be a police officer. Maybe you are. There's a difference there. But generally, questions about whether a police officer's misconduct had to be disclosed to a criminal defendant or handled between prosecutors and police agencies. And then to the next level, we would get the courts involved. But that information, really wouldn't ever go beyond criminal defense to the public. That changed, dramatically in 2020. And so in the summer of 2020, New Jersey implemented a series of pretty sweeping law enforcement reforms that were the stated intent, anyway, was to increase transparency and public confidence in policing. Now, two directives issued by the AG, they were both issued in June of 2020, just a couple of weeks apart. It pretty fundamentally changed how officer discipline would be handled. Uh, the first directive required all law enforcement agencies to publicly identify officers who had received what they called major discipline. And discipline is going to be major if it's something that results in suspension of more than 5 days and is in certain categories of offense. So that was new. And for the first time, agencies were required to publish annual reports identifying officers who'd been terminated or demoted or issued significant suspensions, along with a brief description, essentially, of the event and the misconduct. The AG also required agencies to release a one-time report identifying officers who had received major discipline during the prior 20 years. Right, so we're going to go back 20 years. Everything any officer did and any major offense had to be disclosed. That was a major departure, speaking of major discipline, from Jersey's longstanding approach to confidentiality. There was litigation that followed immediately, as you might expect. And ultimately, the litigation made its way up to the Jersey Supreme Court. And the court limited but upheld some of the AG's authority to require disclosure of major discipline involving police officers. And the court did address that officers had legitimate confidentiality and privacy concerns. But it concluded that the AG's broad statutory authority to establish statewide law enforcement policies justified this new level of transparency and reporting in law enforcement. And so, those decisions, there were a couple of them that were, Rivera was a big one, Higgs is another big one, addressed the public disclosure of discipline, but they didn't answer, or Rivera didn't answer a different and increasingly important question, and that's how should prosecutors identify misconduct that has to be disclosed under Brady and Giglio. And what was happening before that is different. Prosecutors might have different opinions over what needs to be disclosed or doesn't need to be disclosed. Some prosecutors would have different opinion over how much information they would require of law enforcement agencies in their jurisdictions. So we had just different levels of scrutiny, no consistency from place to place. And what the AG's office attempted to do was impose a consistency framework on the Brady disclosures within the law enforcement team. So the information going from the law enforcement agency to the prosecutor's office so that everybody at least had the same stuff. And you had to share that with the state attorney general's office so the attorney general could kind of compare and make sure that the same standards were being applied in different parts of the state. And so, the AG issues guidance that directs these county prosecutors to develop procedures to review officer misconduct, that might constitute impeachment material, Brady Giglio stuff. And over the years, there was no consistency in the way that the information was reported. And so what the AG did was they developed an appendix, a form. It's called Appendix K, and it's referred to in this case. And they call them Appendix K reports. And this is a standardized report that summarized, sustained findings that could bear on an officer's credibility. So the reports themselves weren't the discipline files, but they were essentially an internal prosecutorial tool to assist prosecutors in evaluating whether information should be disclosed to criminal defendants under Brady. So consistency was really the idea. And they fleshed things out, on an annual basis and updated things. And by the time of this case, New Jersey probably had and probably still has the most formalized system for identifying potential Brady material. We have internal affairs findings flowing from police agencies to county prosecutors for evaluation and then disclosure to the state attorney general. Why is that the case? Because the AG has such authority in New Jersey. They can compel the agencies to do that. That's unique, among the states. And New Jersey's AG flexed that particular muscle, and that's why we have that system. So, the question then, is that if we have this system now, we have this great standardized reporting system that gives us all kinds of information regarding officer credibility, and that's shared with prosecutors. Why can't defense lawyers get that? Right? Shouldn't we be permitted to see the reports themselves if they're generated and sent to the attorney general's office? Um, and that's where the tension, really has been. There was a case called State v. Higgs um, that made it up to the state Supreme Court that rejected this notion that defense counsel automatically gets a prosecutor's internal Brady files. That's not how it's supposed to work, right? Prosecutors do have this affirmative obligation to disclose information, but that obligation doesn't require production of everything, right? And there's a process, and courts are involved in that. So we don't just automatically turn everything over to defense, because it might possibly constitute Brady material, although some prosecutors see it that way. The Supreme Court in Jersey in the Higgs case said that's not how it works. Then there was another decision that was pretty interesting called Rivera versus Union County Prosecutor's Office that involved in Jersey this common right law of access to information. So this isn't defense counsel in a criminal case asking for information in relation to that prosecution. This is just a request by the public for information, right? And in Jersey, we have a public records law, and we call it ORA. It's basically the Public Records Act in Jersey. But there also is a common law right to information. And the two, as you might expect, the statutory rights and the common law rights overlap to a certain extent, but they're not the same. And so under the Oprah statute, there's a statutory framework kind of built around and intended to codify essentially the common law doctrine, but it's much broader and maybe not as deep. Under the common law, there's information that one could get that they might not otherwise be able to get under the Oprah law, but they have to establish a right to that information as opposed to just, I'm a citizen. So if you establish like a real need, then you have a chance of getting this information. So it's a balancing test that the courts go involved in. Balancing tests are nuts. That's where, whenever there's a balancing test, and we see this all the time, in constitutional law and these tests, it's really like, there's only two things that matter. One, how good is your lawyer? And two, what are the judge's personal biases? That's it. That's every single case that involves a balancing test. I promise you, that's where it works. That's how it works. And so we have these two Jersey cases, Higgs and Rivera, that create this kind of framework, right, for the dispute that is involved in this case. And so Higgs, made clear that criminal defendants don't automatically get an entire investigation file, and Rivera, confirmed that, people, may be entitled to information above and beyond what they could get under the public records law, based on the outcome of a balancing test, applied by the court. And so, how did this case come about? It started with an inadvertent disclosure. And so what happened is in 2023, the AG's office was updating their website. And as part of like just updating the website, moving things from portal 1 to portal 2, wherever is involved in that, they mistakenly posted a full Appendix K report on their website. And it was quickly removed. I don't know how long in the case notes, like how long it was posted, but it was posted long enough for someone to get a hold of it. I promise you this, in our social media cases, you can tweet something stupid and you could take it down within an hour. Somebody screenshotted that thing. It's going to come back and catch you. And so they disclosed a full Appendix K report mistakenly. Now, before that, there was a section of these Appendix K reports that was just like this broad kind of summary of, here are the number of internal affairs investigations that we conducted this year. Here's a general description of kind of the outcomes of those things. And we investigated an officer for excessive force. There was discipline imposed. But it was really, really, really general stuff. And it's really more stats. Those reports, though, the full reports that the AG's office got everything underneath that, the underlying internal affairs report, names of witnesses, a ton of information that was never disclosed to the public before. And that full report is what was inadvertently posted on the AG's website in 2023, right? And so that makes its way out there. This full report, we've got summaries of misconduct, we've got prosecutors' memos, analyses, and information, weighing, whether there are disclosure obligations. It's like a gold mine, for criminal defense attorneys. And so the public defender, they find out about it. Like, this is great. They get the report and they review it. And then what do? They submit a request initially under the public records law. They say, we want, you posted this, this is public. We want all your other ones for the last 10 years, right? Um, that's where the fight starts. The request makes its way, it goes up through the Attorney General's office. Basically, is how this works. But the government, let's just say, denied the request and said, you don't get that information. It's not public information. There's lots of reasons why we withhold it. The state there, the defenders then tried to tailor their request a little more. And they said, well, we don't need to go back 10 years. Let's just go back 5 years. And we're only looking for certain types of information. You can redact the rest from the report. And the government said, no, we're not going to release it. This is private. It was a mistake. Just because we did it once doesn't mean we have to do it forever. Then the Defender Service, and this is where we get this case, the Defender Service walked away from their attempt to access the information under the public records law. And instead, what they did was they filed a lawsuit alleging that the government was violating their common law right of access to this information. So we're essentially using a different argument. And the argument that the Defender Service says, this isn't a criminal case. So I'm not a defense attorney asking in the context of one particular prosecution. We are the Office of Public Defenders. And so if there's a report out there, for an entire county that identifies a whole host of, possible issues bearing on officer credibility or bearing on the agency's credibility, how are they responding to certain things, right? We are in a unique position to determine, to have access to the information because we are essentially, the other side of this process of ensuring that there's fairness in the criminal justice system. And so we have an enhanced need for this information, which under a balancing test might get us access to it. And that's what the court wound up weighing, in this case, is what was the defender's service, what was their right to this information? Did they have any type of enhanced argument that they should have access to the information or not? Versus the government's, arguments that, wait a minute, this is really serious information that's contained in these files. You may have a valid interest in officer credibility generally and the legitimacy of agency investigations, but that doesn't mean that we're going to turn over an entire investigation file to you with every officer's name, every witness name, every thought that anybody had on any of this kind of stuff. That goes too far. What the appellate court wound up doing in this case was essentially conducting that balancing analysis and sided, to a certain extent, sided with the Defender Service and said that the trial court erred when it dismissed the lawsuit. And what happened actually after the lawsuit was dismissed, the Defender Service by the trial court, the Defender Service asked for reconsideration and then said, "Hey, what if we redact these things?" And they significantly reduced their request. And the court said, "Look, too late. You don't get a do-over. This is rejected." What wound up happening was the appellate court looked at that and said, "That's not a bad idea." And so the appellate court remanded it to the trial court and said, we're not just going to say you don't have any access to this information at all. What we're going to do is we're going to require the trial court to go through these Appendix K reports and redact certain information. But you're going to get, they're going to have to disclose more information than they wanted to. And some of the information that was inadvertently disclosed and would not ordinarily have been disclosed was forced to be disclosed in that particular case. And so that's where we left that one. Interesting, because a lot of the information, is essentially discipline information related to police officers. And so that's just another thing that we need to keep an eye on, at the local level, labor relations. If we're going to have lists, if we're going to have procedures, what's the potential blowback going to be? Who's going to get access to this information? And is that a good thing or a bad thing? In this particular instance, I do think that the appellate court in Jersey made the right decision. But there's a pretty significant risk there that a lot of otherwise private information involving law enforcement officers could have been disclosed to the public. Okay, our last case comes from the state of Iowa. It is Bart Richmond versus Jefferson County Attorney. This was decided by the Iowa Supreme Court in May of this year. I think this is going to be in next month's newsletter. We like state Supreme Court decisions, right? They tend to, sometimes they can be very, very interesting. And I love this decision. This is a really interesting Brady decision that, addresses due process rights of officers in connection with Brady disclosures. That's an issue that's near and dear to my heart. I litigated that issue in Pennsylvania. We have some pretty good law in Pennsylvania, as a result of a lot of that litigation. And I should shout out Ralph Tatey, my retired partner, who is lead counsel in a really significant Brady decision out of Pennsylvania involving FOP Lunch 5, identifying a due process right based on the privacy interests of individual officers. And so in Pennsylvania, while we're talking about this in Pennsylvania, if it's very clear in Pennsylvania that officers have due process rights in connection with their placement on or removal from a Brady Giglio list, and that analysis includes an impartial review by a third party, right? Not just the DA. It's going to say, "Oh, let me take a look at it again." No, you can have a third party to take a second look at whether an officer's placement on the list or not is appropriate. Good law in Pennsylvania. Lots of states have, or actually not many states, but some states have pretty good law on this stuff. And Iowa's one of them. Iowa's got great, and there's some, I think 3 times in the last 5 years. I could get that wrong. It definitely is twice. It might be 3 times. Iowa passed legislation addressing Brady rights of police officers. And, these are procedural statutes, really. I mean, there's some substantive aspect to it. But, what the legislature did in Iowa was put a framework around the processes that are to be used in connection with the prosecutor discharging their Brady obligations. And prosecutors all the time say, I have this discretion, I have these constitutional obligations, and they'll throw Brady at you a million times, and they talk about the rights of the constitutional rights of criminal defendants, but they forget that officers have rights too. Right? Or they just don't want to talk about those rights. And that's what the officers do. And that's what the police union does. And so this case out of Iowa is an interesting challenge to Iowa's statutory framework over that. And it really gets to this question of what process is an officer entitled to before a prosecutor can formally determine that they are a Brady officer. Again, no one's saying that a prosecutor doesn't have an obligation to disclose impeachment evidence. But what is the process that's going to be used there? That's something that a lot of times falls by the wayside. Can a state, regulate the processes to be used in connection with discharging that obligation? Absolutely. Absolutely. And so, what did they do in Iowa? Beginning in 2022, the legislature enacted Chapter 80F of the Iowa Code that creates a formal process for what the statute calls potential impeachment information. And so rather than allowing prosecutors to just make unilateral decisions behind closed doors, the statute requires county attorneys to notify officers when they're considering placing them on a Brady list. It requires the prosecutor to notify to identify the information at issue in that notice and to provide the officer with an opportunity to respond. All right. So, Officer Polson, I've been made aware of a suspension involving dishonesty. I believe that this requires Brady disclosures. I'm going to put you on our Brady disclosure list. Here's the suspension I'm relying on. Here's the information I have. What say you? Right? That's essentially what the statute requires. And it also provides judicial review of final determinations. And so, I've made my initial determination as a DA. Or preliminary determination. My mind's not made up yet officially, but here's what I'm probably going to do. I'll give you a meeting. You can meet with me, and maybe I'll change my mind. Maybe I won't. In lots of parts of the country, you have the meeting, and if I don't change my mind, tough. You got to pound sand. In Iowa, you can go further, and you can take that determination to court if the officer still disagrees. Uh, that exists in Pennsylvania under the common law, and New Hampshire has a statutory system. There are some places that have systems around this; most do not. And so, in this particular uh, instance, we do have legislation. The legislation was controversial, and the reason why we don't have legislation in a lot of states regarding this is because the DAs hate it, right? The prosecutors oppose it. And state legislators, a lot of times, I get to work, as legislative counsel in a state legislature, for police labor organization, and I can tell you that the police union is going to be a stakeholder, right? When there's a criminal justice bill, something having to do with crime, yeah, you're going to consult with the police union, and you're going to consult with the chiefs, and you're going to consult with the DAs, and you're going to consult with the victims' rights groups. We want to talk to all of the stakeholders. There's not a lot of interest in any state legislature moving on any criminal justice legislation unless everybody's on board, right? And if you've got all the stakeholders on board, you got a good bill. Well, if you've got Brady legislation and you've got the DAs arguing with the chiefs, arguing with the police union, it's going to be really hard, right, to get that stuff across the finish line, which is why many states or most states don't have legislation around this. It was a significant achievement in Iowa that the FOP got this done. I think the FOP was really a big mover there. And so it was controversial legislation. Prosecutors argued that, our Brady obligations come from the Constitution. The legislature has no place interfering with my duty to determine what information has to be disclosed, right? This is the Constitution. Stay in your lane. This is mine. And the police organization said, well, no, nothing in our legislation prevents disclosure of Brady information to criminal defendants. What we're doing is we're trying to address the constitutional rights of officers, by the way, and also we're attempting to, just like in New Jersey, they wanted to have consistency right across the state. We're attempting to inject a consistent standard for weighing these questions, right? Because they're such important questions. So that we don't wind up in a situation where an officer's reputation is ruined or their career is permanently affected. And so those were the competing interests there. And so what happened in Iowa was we have this Richmond case, and we have funny, basically. This is a pissing match between the DA and sheriff. And so we have a DUI arrest. The DUI arrest results in somebody being cuffed, and then there's a force issue, and a complaint about a use of force. The DA reviews the body cam footage and looking at the DUI arrest, and basically doesn't like what he sees. And so he contacts the county and says, I want to see your use of force report. But the agency, they didn't have an issue with the use of force. If you look at the case, there really wasn't an issue with the use of force, but the DA didn't like what he saw. And so he asked for the use of force policy, and the sheriff basically just ignores it. And so a week later, the DA says, hey, I want your use of force policy, and basically says, and if you don't give it to me, I'm going to assume that you actually believe that these officers violated the use of force policy and you haven't done anything about it. I'm going to have a problem with that. And so what did the sheriff do? The sheriff blew him off again. And so this is great. So I don't know any of these guys, but I know all of these guys, right? You have a DA trying to nose his way into the law enforcement agency, and the chief essentially saying, get out of my hair, right? You stay in your lane, I'll stay in mine. And so when the sheriff didn't respond the second time, the DA got an independent review of the officer's conduct and got an opinion that the use of force was inappropriate. And ultimately, what the DA did was he put the sheriff on the Brady Giglio list, and basically puts the sheriff on the list, notifies the sheriff, I'm going to put you on a list pursuant to this, our statute, and we're going to have a list placement interview, which is what the statute requires. and it's going to be on Monday at 2 o'clock. And the chief says, "This is ridiculous, but I'm going to bring my lawyer. My lawyer can't make it. Can we do it next Thursday?" The DA says, "No, we're just going to do it this day, come or don't." And the DA basically said that the sheriff's refusal to provide the use of force information or information about his investigation called into question the sheriff's quote judgment, credibility, candor, and truthfulness. Subject to the point now, well, I think I might have to disclose that to defense counsel. And so that's what he did. He disclosed that not just to defense counsel, but sent around the notification, right, to the law enforcement community in Iowa. This really extraordinary thing. And basically said that this sheriff should no longer be considered a credible witness and that he shouldn't place himself and shouldn't be asked to place himself into positions where he may be called as a witness to testify. Extraordinary action. What did the sheriff do? The sheriff appealed. And there's a way to do that under the statute. So he requested reconsideration of his placement on the list, and he was successful, right? Which is, of course, not surprising if you understand anything about this stuff. I mean, first he asked for a reconsideration meeting, and the DA didn't change his mind. Shocking, right? And then he filed a petition for review, and he was successful, and in district court. And so the DA appealed the district court decision, and essentially raised this constitutional issue, stating that there is a significant separation of powers problem in this case because the court is now telling me how I can or can't, and the legislature, by virtue of the statute, is telling me how I can or can't discharge my obligations under Brady and Giglio. That was the argument, right? And the court, I think in a really, it's a nice little primer in the decision. The Supreme Court gives us a nice primer on Brady and Giglio issues, and then it pretty handily gets rid of the appeal and sides in favor of the sheriff and not the DA. And so, why was that the case? Well, the court made very clear in the decision, frame the issue and correctly, stated that the case wasn't about whether this prosecutor or any prosecutor has to disclose impeachment evidence, right? Everyone agrees Brady and Giglio are controlling constitutional law, and there are disclosure obligations consistent with the Constitution. The court said the case isn't about that, right? The court is instead about whether the legislature can regulate the procedures used by a prosecutor in making that determination, right? Pretty big distinction, and that basically drove the entire opinion. And the court rejected the prosecutor's argument that the legislature interfered with his Brady obligations by virtue of the Brady law, Chapter 80F. And it said that nothing in the statute prevents prosecutors from complying with their constitutional duty to disclose favorable evidence, right? So, even if an officer successfully challenges a Brady designation and gets removed from the list, prosecutors are still obligated to disclose impeachment evidence, whenever it's required, right? What we're talking about, what the court said, we're talking about whether somebody is placed on a list or not, right? So, the statute talks about, procedures, right? And protections that might be put in place for officers and for criminal defendants. But none of that has anything to do with the prosecutor's ultimate obligation to disclose things. And essentially, the court said that Chapter 80F doesn't tell prosecutors what Brady requires. It just establishes procedural safeguards before an officer is formally designated under this statutory system. Really interesting decision. If you have any interest in Brady and Giglio things, I urge you to read Chapter 80F. It's probably the best law on the books out there. New Hampshire has a good one. But I think Iowa really is at the head of the class right now with respect to legislative protections and balancing the competing interests of prosecutors and of police officers in making sure that we don't go too far one way or the other in protecting the rights of criminal defendants or individual police officers. The Supreme Court did it's a concise opinion. It sets out the basics of Brady and Giglio, and I think it provides a really helpful decision in addressing one of the arguments that prosecutors make in legislatures, that this is there are real separation of powers issues. I think the court addresses this pretty well. And, I think that this is going to be a meaningful decision that will be cited in state legislatures, as I know there are lots of bills pending in different state houses to try to do something similar to Iowa. And I think that because of this decision, prosecutor groups, right, the DAs associations, et cetera, are going to have a much harder time in separating themselves from the group and in pushing back on legislation. So hopefully, this will wind up with one of the outcomes of the Iowa decision will be, more wind in the sails of legislative efforts to provide procedural protections in the context of Brady and Giglio issues. So we shall see. And if there are any developments, hey, if you know what's going on in your state, if you have an interesting bill or success, please let us know. Email us at info@lrs.com, and we'll be sure to share that stuff with everybody in the future. Okay, that brings us to our final thoughts, and you know, um, three different looks at Brady, right? So rather than thinking about these as three just different, individual cases for Virginia and New Jersey and Iowa, I think they're snapshots, hopefully of just a larger trend. This Brady Giglio stuff has worked its way from the courtroom to agencies and to state houses, and that's not going to change, right? And so we're going to see more legislation attempting to standardize and kind of formalize procedures around disclosures from law enforcement agencies to prosecutors, right? And have similarly consistent processes in place to address real concerns by law enforcement officers over their placement on or removal from Brady Giglio lists, because this can impact their careers. And so, the cases help us look at three different things, and they also have us pay a little more attention to cell phones and personal cell phones. It's something that we're going to keep talking about for years, because I don't think the law is going to get much better on that stuff. So, three looks at Brady, a little side of cell phones. Hope that helped everybody out this month. We'll be back in September. Not sure what we're going to be talking about. Maybe we'll be talking about the 76ers again. Maybe they'll sign Michael Jordan. Who knows? But until then, if you want any information about anything we're doing at LRS, please check us out at lrs.com. Come on out and see us at our seminars. We're going to be in Vegas in September. We're going to be in Nashville in November. You can get all that at www.lrs.com/seminars. And as always, follow us, like us, text us around, share it, spread the word. And if you have any particular questions for me, just shoot me an email, info@lrs.com. Thanks a lot, everybody. Hope you have a happy and safe rest of your summer. I'll talk to you in September.